If you receive one of these today, you're probably going to have a better day today than if you received one of these. Because the first are my theatre tickets. I'm off to see a show, Two Men in Verona, I think it's called, something like that. And the second is an ESOS enforcement letter. Okay, if you get an ESOS enforcement letter, it's absolutely critical that you act on it. Don't ignore it. In this video, I just want to run through an update for 2025 about what you should be doing. Okay, so buckle in, hope you like it. So first off, let's assume you've got an ESOS enforcement letter. If you didn't get one, or you're not in ESOS, you can probably skip this video, it's not for you. But let's assume you got one. What do you need to do? Okay, this is the 2025 update for that. Well, the first thing to do is to not ignore it. These are legal documents, okay? The Environment Agency does have power. It's got power granted by government, and it does act. So if you think, don't worry, it'll go away, it won't. A few of my clients thought that it doesn't work. Similarly, if you think, do you know what, I'll just ignore it, not much will happen. Again, same problem. You know, yes, something is likely to happen, and you know, if you don't react to them, they will take legal action. Okay, so first off, let's just go through the letter. Let's go through the letter first, then I'll tell you about, you know, the sort of implications of getting the letter. The letter's split into different sections. This one's 1, 2, 3, 4, 5, and this one's real. I mean, this letter I'm holding here is from a real client who received one, unfortunately, not one of my previous clients or existing clients, but someone new to us who sort of came to us saying, I've got one of these, what do I do? And we've done a lot of these. So if you get one of them, my first sort of tip for you is give us a call. We know what to do with them. We know how to react to them. We know how to process them, but don't ignore it. That's my first big tip. You'll hear it a few times in this video just to kind of get the message across for you. So the letter itself, what does it say? Well, it says to start with, you're in breach of the regulations. So the ESOS regulations are set out in law. They were put into effect, I think it was either in 2013 for effect in 2014 or fresh in 2014. They were updated a couple of years ago, but they are regulations. They are legal requirements, okay? And it's legal requirements on the company. Now, the letter itself says you're in breach of those regulations, and what they're looking at doing, what the Environment Agency are doing, are looking about what to do about that breach. The most likely outcome of the letter is you are going to receive a fine, okay? So sorry about that. And it can be quite significant. It'd be like, you know, I've seen fines across my desk of 70 grand, 60 grand, 57 was one of them. It's quite a low one. But they are quite significant. And I come on a little bit more about that a bit later and what you can do to sort of reduce the level of the fine. But the first bit says you're in breach and you've got to act. Second bit says, well, what is it? The third part is the actual enforcement notice itself. This is page 3. That's the actual components there of the enforcement notice. And the third part is the one that actually says, you know, yeah, you know, here's the law, you didn't do it. The first part's kind of preamble. Then it's got what to do to appeal. Now, you can appeal. We certainly do appeal for clients, but you know, you've got a pretty strong grounds for appealing. And the grounds that, you know, I didn't get the letter, or it got lost, or so-and-so was supposed to deal with that, they didn't do it, don't cut it, okay? All of those are very weak grounds for appeal. Correct grounds for appeal will be something like, this letter was incorrectly addressed. You know, you sent this to the wrong person. I've seen that on one occasion. Good grounds for appeal are, no, we are not in ESOS for the following reasons, and here's the evidence. Okay, you have to give them the evidence. You can't just say, no, we're not. You have to kind of back that up with sort of, you know, hard fact. But they're good grounds for appeal. The most common reason people get these is the person dealing with it just wasn't aware of it. You know, so probably about 4 out of 5 cases I get are from people saying, look, I don't know what this is. So-and-so used to deal with it. They left the company and, you know, it's landed on my desk. What do I do? That's extremely common. And that's sometimes because the person dealing with it was the only person who knew this sort of stuff. Another reason is just emails getting lost, email and letters getting lost. Again, if you could demonstrate that and prove it, you probably could appeal, but you're on thin ground because it's your responsibility as directors or trustees of an organization to comply. You're not, you know, you don't have to be told by the Environment Agency that this is going to happen. Okay, so it's not a case of, well, you didn't tell me, so I'm not doing it. The obligation is on the directors and the trustees to know what's going on and know the law. What was it? Ignorance is no defense in the eyes of the law, I think is the phrase. So the appeals criteria is set out on the next page, page 4. And, yeah, we can make an appeal, especially if there are extenuating circumstances. But that's probably in the region of, let's, sort the enforcement notice out now, make an appeal if you've got strong grounds, and then put the appeal in so that we can reduce any penalty that's going to happen later. And I'll come on to that in a second. The last section, section 5, is a list of what you've got to do and critically when you have to do it. Now, unfortunately, I'd say probably around about half the ones I get of these, the dates in the past. So, the Environment Agency will issue a series of letters leading up to the enforcement letter saying, please comply with ESOS. We need some information to see whether you do or you don't, etc. And then intention to apply an enforcement notice, and finally this enforcement notice, and then later on there'll be the actual penalty itself, the penalty letter itself. But the one I'm holding in my hands, this says you have to comply with the following stipulations, and there's 3 down here. But the date that they had to comply by was months ago. So this is just bounced around internally, and whoever received it didn't deal with it at the time. And as I say, my first big tip, second time I mentioned it in the video, is if you get one of these, get in contact with us. Go to anistic.com, drop me an email, a YouTube video, whatever it's going to be, comment, whatever it's going to be, get in contact, don't ignore it. So this one in the last page gives them 3 things that they have to do, this organization. The first is, in the column it says, what the problem is. The second column, see if I can do this back to front, is what you've got to do. And the third is the deadline date, when it's got to be done by. Normally the deadline dates are all the same. So the first one is you didn't carry out an ESOS assessment. So the required steps, and these are not requests, these are orders, okay? This is a legal document. You are being ordered to do the following. Carry out an ESOS assessment, okay? Just because you haven't done one and you get an enforcement letter doesn't mean to say you don't have to do one. You do, okay? So the first step that you're ordered to do is carry out an ESOS assessment. The second step is to file the ESOS report. Now that's the process that we do at the end of the process when we prepare the evidence pack, etc., and we file it on the ESOS system. Again, your ESOS lead assessor, anistic, or whoever will know how to do that and carry that out. And the last one is to provide evidence that you're going to be doing it, yeah? Sorry, the last one is provide evidence if you don't think you're obliged to do it, why? And as I say, that evidence has to be pretty darn strong. So there's 3 things you've got to do. The first 2 are actually compulsions. You must do the following. The third one is kind of, well, if you don't think you're in, you must tell us, okay? And that's the thing that's in the last schedule. Now, let's talk about what will happen after this. Well, to start with, if you ignore it, the world will rain down on your shoulders, right? So, you don't want that. The Environment Agency do have teeth and they do need you to comply. It's not a request, it's an order. The second thing is you're likely to, so you must carry out an ESOS assessment. So, drop us a line, we'll help you, but please do it. Okay. The other thing that's going to happen is you will be referred to the penalty process, where they set a level of penalty based on your size of company, and then they go through several mitigating factors. One of the critical ones here is what you did, how fast you reacted once you realized you were in breach. So, you didn't do what you should have done, and so you are in breach. When you found out, how quickly did you respond? And I think there's a clause in the penalty sort of sections that they look at how you react as well. I mean, I don't think you need to go there and say, look, I'm very, 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 very sorry. I'm going to grovel back to the Environment Agency, but you do have to sort of show some form of admission and action, and critically, the speed at which you react is also going to play a part. So they'll set the penalty, they'll then apply any sort of adjustments to that, and then if there is an appeal, if there are mitigating circumstances, use your ESOS lead assessor, be it anistic or someone else, to actually formulate that in, we call them pleadings. I mean, we're not lawyers, but it's similar to the stuff you get in court, where they actually say, look, honestly, here's why it happened, what we're going to do in future, stop it happening again, etc., etc. But what are the circumstances of the penalty? So those things are the way they set the level of penalty. As I say, most penalties I see are somewhere between 50,000 and 90,000. That kind of level of penalty being issued. Okay, and they're real. People are paying these. So it happens. Right. So that's what you've got to do. The last bit I'm going to say in this kind of 25 update for you is there are other things out there called ESOS action plans and ESOS action plan updates, and we have got ESOS phase 4 heading our way. Most of our clients are starting that. Probably the early planning meetings we're now doing in Q3, Q4 of this year, with a view to starting work on ESOS, the assessments, building the evidence pack. Start that with our larger clients in early 26, the majority of clients by about Q2 26, ready so that when we've gone through 26, we've done all the audits that are required, we've got all the evidence pack, we've got the data, and there's plenty of time there to check it to make sure everything's right before we submit it, probably in 2027. The deadline is 5th of December 2027. That's the kind of drop dead date. Okay, so that's what you get. As I said to you at the start, if you get one of these, you're going to have a way worse day than you get like a letter for that, which is the theatre tickets. My sympathies. The last time I reinforce it is get in contact with us. Do not ignore it, because it's not something you can ignore as a company. Okay, so there you go. I hope that was useful for you. If you get any other questions surrounding ESOS or SECR or SBTI or EPDs or any other acronym you can chuck in there to do with sustainability or carbon accounting, let us know. And if we can help, do you know what? We certainly will. All right, I'll see you next time.